Hello, this is Matt on the Moon Family Sedan channel, and here's a headline from the Crypto Basic, which I think will catch the attention of pretty much any XRP holder within our community. The headline is, Deaton says ruling in SEC v. Ripple lawsuit could come tonight. Now, it's worth noting that when he said that, it was last night. At the time I'm recording this, what the hell day is it? It's Tuesday, isn't it? Yeah, it's Tuesday. And at the time of recording this, in case anyone's curious, it's 4:49 a.m. So, he said tonight, but obviously it's now morning, so that didn't happen. But why did he state that? Well, there was a major development yesterday. I'm sure many of you are aware at this point. If not, I encourage you to check out my very last video. It was almost 40 minutes long, but we got a ruling from Judge Torres yesterday, not regarding summary judgment, but the ruling having to do with experts either, their testimony either being rejected or accepted effectively. And it was very positive for Ripple. The net plus for Ripple. SEC got some things that they wanted, but it was a much bigger win for Ripple and thus XRP holders, I'd certainly argue. And I don't want to rehash that since I did a pretty intense breakdown already. But if you're wondering what caused John Deaton to state that, it's that ruling. Because, look, John has said, yeah, of course it's possible that we could see a ruling on summary judgment from Judge Torres in March, but he's also warned that, it could be April or May. But the fact that we have already seen that particular ruling come out literally yesterday, March 6th, that is what triggered him to state, really, it's effectively, not to put words in his mouth, I'll show you exactly what he said, but effectively I think the message he's conveying is it could imminently come out. And also I want to talk to you, since that's the case, I want to talk to you a little bit about what we can expect moving forward, because frankly, there's a very real possibility that, when we get this ruling, even if it's positive for Ripple and positive for XRP holders, there's a real possibility that the saga does not end there. There's an article I want to share with you from somebody who was on until last year, an SEC advisory committee, working directly with Gary Gensler, mind you, and he's not fond of Gary Gensler, and he's warning, frankly, this is going to have to probably go to at least the appellate level, so there's virtual certainty there's going to be an appeal, and it's also quite possible this goes all the way to the Supreme Court. Now, what's that mean for XRP holders in the meantime? Well, it depends on how things shake out, so let's talk about it. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so into the first piece here. Deaton says he does not expect Judge Torres to significantly delay in giving her ruling on summary judgment motions. Attorney John Deaton has opined that the ruling in the United States Securities and Exchange Commission case against Ripple is imminent. The crypto law founder, who represents thousands of XRP holders as a friend of the case, made this known in a tweet today in response to inquiries about whether the release of the judge's decision on Dalbert motions gives any hints on the timeline for her summary judgment decision. Deaton expressed doubts that there would be significant delays. The lawyer noted that the judge could release her ruling as early as tonight or in a few weeks. Yeah, and I'll pause. He's not the only. I can see exactly why I was thinking this. There's all sorts of attorneys that were speculating that this indeed might be the case. I'm going to share with you another opinion from another attorney within our community, and he ends up highlighting something that was stated by Attorney Filan, another member of the XRP community, who noted, that there's a real good possibility that these could be either issued at the same time, both rulings in terms of the rulings having to do with the experts as well as summary judgment, or they could be roughly back to back, which is why we're at a point here where I'm going to be constantly checking crypto media and social media for updates, because we really are at this phase where any day now it really is possible and perhaps probable that we're going to see the judge's decision. It's going to be out very, very, very soon, and this is just making everyone think that it's more likely than not, like literally that imminent. Before that, it was a little less certain, but it seems highly probable that, yeah, this is the direction we're going, and Attorney John Deaton is convinced of that as well. And so here's the actual tweet. And he was asked by an XP community member, any hint here as a result of this ruling coming out yesterday, any hint kind of remaining until, the timing for the summary judgment, that ruling to come out. And Attorney Deaton wrote, I seriously doubt that we see a significant delay from here. Could be tonight or in a couple weeks. And so, look, we don't know, but the fact that this happened again, like I just said a minute ago, leads one to believe that perhaps this could occur imminently. And attorney Fred Rispoli, member of the XRP community, said the following. He said, because he was asked, as far as the timing, what exactly are we looking at here? And he said, I would say this month. James Filan suggested we'd see a likely simultaneous ruling on experts in summary judgment, and that made a lot of sense. So summary judgment is either coming out at any moment, or Judge Torres is dropping this one first to cajole the parties into settlement at the last chance. Now, that's an interesting theory. And, I buy it. I buy it. I'm not saying that I believe with some high level of certainty it's going to happen, but I can buy the concept. It's plausible. Because if you are aware of what happened, and if you're not, again, check out my very last video. If you're aware of what happened and the degree to which this is beneficial for Ripple, it might send the SEC a signal, a message here that, this might not go so well for you. And there are a lot of reasons for that. I mean, some of the strongest arguments the SEC is making were outright rejected by the judge. They can't even make the arguments in the case. So it's plausible, at least, to note that perhaps it's the strategy of Judge Torres to just, get the parties talking again, see if they can finally reach settlements. Now, I'm not optimistic that's going to happen, but plausible theory for sure. And then there was this article shared by John Deaton's crypto law organization, and this is where we got to talk a little bit about what can we expect moving forward. Because, the idea of this case concluding, we'll see what the judge's ruling is, but the idea of the ruling coming out, and then both parties are like, okay, yeah, I guess it's over. The idea of that happening, perhaps slim. The idea that somebody's going to appeal, whoever loses is going to appeal, well, perhaps very high probability. And so this is J.W. Verrett, who wrote the article. I'm going to share with you a couple key portions of it. He's the guy on your screen here. And I've covered some stuff from him on my channel before. He seems like a very intelligent, very sharp guy. He was on the SEC advisory committee until his term ended, and this was as of about a year ago. So he on March 15th of last year, he wrote the following: upon my term ending on the SEC's advisory committee last week, I took the chance to give Chair Gensler some strong words about his abuse of digital assets. And he told him straight to his face, and I remember covering that in a video at the time. And now he's got some additional perspective here in a brand new article, which was published literally yesterday. And the timing of this is just perfect, given that we're at this point where the judge already issued this ruling having to do with the expert witnesses. And now we're looking at, okay, what's going to happen once the ruling comes out, which does seem to probably be imminent. And so this article is titled, "Crypto is a Major Question Only Appellate Courts Can Answer." And so I printed this thing up, and there are a couple key portions I want to highlight, not literally the whole thing, but I think you're going to find this interesting because you got to be wondering, given that we are at this phase where we're really at the finish line here, what happens next? Because someone's going to win, someone's going to lose, right? And I mean, there could be a little splitting of the baby, so to speak, as we've been talking, but even so, I don't know that it's likely to end after this ruling is the point. But anyway, a piece reads as follows. Crypto enthusiasts and securities lawyers alike are awaiting the resolution of the U.S. Securities and Exchange Commission's case against Ripple Labs, Inc. and its founders over their distribution of the cryptocurrency XRP. The SEC alleges that there was an unregistered sale of securities when XRP was first distributed, as well as unregistered subsequent distributions. Under former SEC Chair Jay Clayton, the Ethereum network was appropriately blessed in guidance from the SEC's Division of Corporation Finance Director as not meeting the Howey test for what is considered a security, but the distribution of XRP instead was met with a midnight enforcement action approved in Clayton's last days in the role. The deck is usually stacked against defendants in cases of this type, as existing interpretations of what must register with the SEC are fairly flexible. But Ripple has argued strenuously that there are limits to that flexibility when it comes to this new asset class. Yet, no matter how SEC v. Ripple Labs Inc. is resolved at the U.S. District Court for the Southern District of New York, conventional wisdom is that the losing side will appeal. When it does, this case may become the vehicle by which administrative law itself is transformed by the U.S. Court of Appeals for the Second Circuit and the U.S. Supreme Court. So let's pause a note here. If Ripple has an outright win, I think that it's highly likely the SEC is going to appeal. Now, if let's say that the SEC gets a technical win, they get a technical win against Ripple, and maybe it's even just for some specific sales, but the judge indicates that, sales moving forward, obviously these wouldn't count as unregistered securities for reasons A, B, C, X, Y, Z, whatever she ends up issuing. So it's, again, just hypotheticals here. Well, if that happens and there's a path forward for XRP, and the SEC got a technical win, and as a result, the Ripple has to pay a fine of X amount of dollars. Well, if that happens, when you get to the remedies portion of this case, at that point, there could be a demand from the SEC that maybe Ripple accepts this. We'll go ahead and agree to specific remedies when it comes to this case. Now that we have won, we're the SEC, but you have to agree to not appeal the decision of the judge. Now, if under that scenario, as long as Ripple has a path forward to continue to utilize XRP in their business model, and there's a path forward, legal clarity for XRP, I think they take that deal. Even if Ripple loses, I don't think they appeal. If part of the package is a conclusion where there's a path forward for XRP, I don't think they're going to give a damn. Why would they continue the fight? Why would they do that? I don't think they would. So that's why, again, if Ripple gets an outright win, this thing could drag on. If the SEC, and that's why it's so funny to think, if the SEC gets SEC gets a win, but there's a path forward for XRP, it could actually end right there. So I could not be more curious as to know what Judge Torres is leaning towards. We kind of got some hints yesterday, and I think it's probably good for XRP holders at least. I don't know for sure if it's good for Ripple, but for XRP holders, my suspicion is yes. But anyway, piece continues. The SEC has recently brought a series of cases against other cryptocurrency operators, including stablecoins and staking services, with more expected imminently. Meanwhile, the Commission has proposed rules to require decentralized finance protocols in crypto, which are essentially just computer code written onto a blockchain like Ethereum to autonomously settle financial transactions, to register as licensed exchanges, which is impossible. Yeah, exactly. How are you going to get some sort of decentralized system like that to license? When he says it's impossible, it is literally impossible to do. You cannot, even if you could magically get all the participants in the system to try and fill out paperwork, even if you got to that point, which you can't, but even if you could, you can't, you can't fill the paperwork out. Like, who's in charge? No one's in charge. Exactly. Well, not literally no one, but it's a diverse group of individuals. No, of course not. So it's funny and stupid, but piece continues. The Supreme Court has long held that when federal agencies seek to determine a matter of national significance, they must do so using clear authorization from Congress. This has been described as the major questions doctrine by lower appellate courts. In essence, for a federal agency to regulate a major question, the statute must clearly state that the agency shall regulate this issue. And that's a key concept there as we go through this. So again, if you're a government agency and you're doing something big, which obviously the SEC is here, if it's not crystal clear that you have been granted such power by Congress, you're going to have a problem. That's the concept. It's the major questions doctrine. Anyway, piece continues. The phrase major questions doctrine was used for the first time by the Supreme Court in 2022 in West Virginia v. U.S. Environmental Protection Agency, a landmark opinion that overturned one of the EPA's signature rules from the Obama administration. The major question in the case was whether the agency had the authority to regulate greenhouse gas emissions from power plants under the Clean Air Act. Specifically, the EPA had issued a rule known as the Clean Power Plan that set carbon dioxide emissions limits on power plants and required states to develop plans to meet them, but there was no clear authority in the act for the EPA to do so. the agency tried to thread together a number of vague statutory references to justify a congressional grant of authority, but the Supreme Court was not convinced. And so I'll pause to note, this concept right here is why Attorney John Deaton has previously articulated that he believes if the SEC v. Ripple case makes it to the Supreme Court, first of all, the Supreme Court doesn't have to accept the case, but let's be real. They would. For something like this, especially when you're talking about government overreach, oh, they would. And Attorney Deaton has articulated that with the current makeup of the Supreme Court of the United States, it's composed by a lot of people, not exclusively, but by a lot of people who detest government overreach. And I'm talking about from if there's a government agency, as just describe this example here with the EPA, overstepping, pretending like they have authority that wasn't granted to them by Congress, this Supreme Court will smack them down. So we can take some solace knowing that even if this drags out for years, and I really hope it doesn't, but even if it does, if they get to the Supreme Court here, with the current makeup of the Supreme Court, it seems like a virtual certainty that they will smack the SEC back down. They do not have tolerance, and I actually love this. They have no tolerance for government overreach here. And I think we all know, because we've been following this case for over 2 damn years, what we're seeing here is extreme overreach by the SEC. Let me jump down a little bit further in the article, though. The SEC's reliance on a 1946 opinion in SEC v. W.J. Howie Co., which gave the SEC authority to regulate a contract to sell an interest in an orange grove, is an odd fit for crypto assets and well ripe for the application of the major questions doctrine. And to make matters worse, the Wall Street Journal and Bloomberg recently reported that these actions by the SEC appear to be part of an administration-wide effort to simply freeze crypto assets out of the traditional financial system rather than regulate them. That's one more unique fact that heightens the odds that appellate judges will apply the major questions doctrine to the Ripple case. So again, it's all, let's get a pause note again. It's all about government overreach here. The major questions doctrine. It's gigantic, the overstepping that the SEC is engaging here. Couldn't be more optimistic for a positive Supreme Court ruling should it get to that case. To get that place. I don't want it to. I want peace for our damn community. I really do. So if we can find some sort of agreement between Ripple and the SEC after a ruling here, even if Ripple technically loses, I'm all for it. That, and maybe that's even what's probable, frankly. We'll see. Anyway, peace continues. If the U.S. Postal Service... Oh, I love this. This is a funny comparison. If the U.S. Postal Service had sought to regulate email using its authority over P.O. boxes and required that only certified postmen were allowed to deliver this new email, courts would have rightly overturned it with the major questions doctrine. The SEC's assertion over jurisdiction of what is now a $1 trillion asset market and has been as large as $3 trillion is surely a matter of such significance that the vague language contained in the securities laws granting the SEC authority over investment contracts implicates the major questions doctrine. Rather than predict the outcome of the Ripple lower court opinion, it would be safer to predict that litigation over the Ripple case and the SEC's other crypto regulations will continue for years, as the legal questions are far too big to settle at the district court level. Yeah, so pause. That's exactly why, depending on the ruling from Judge Torres, there could be an opportunity for the SEC, if Ripple loses, for the SEC and Ripple to agree on what the remedies are. And then we don't see this thing keep going. But if this is a slam dunk for Ripple here, this isn't over, folks. The SEC absolutely will appeal this thing. I'd be shocked if they didn't, because there's too many legal avenues that they can still take. And then they wraps up by stating, eventually the SEC's discretion to regulate crypto may well be substantially constrained by the major questions doctrine. Until then, this hope will prove little solace to crypto entrepreneurs seeking to come into compliance and those who just want to understand the rules of the road. Very well written. I think that's insightful too. Because look, I've mentioned a few times, how Attorney John Deaton has shared his perspective that, seriously, if it comes down to a Supreme Court ruling, yeah, very optimistic Ripple wins. But what about additional logic behind that? And that's part of the reason I wanted to cover this, because I haven't really covered it at this level of detail. And his article did such an awesome job explaining exactly why, in plain, simple words that anybody with half a brain can understand. It's the major questions doctrine. We've already seen how the Supreme Court rules in situations like these. This would apply with the SEC v. Ripple case. So should it get there, yes, we'll have a happy ending. I'm more optimistic about a positive ruling at the Supreme Court level than I am at the district level with Judge Torres. And I'm still optimistic. Don't get me wrong. I am definitely optimistic even at the district level, but I'm much more confident about what would happen at the Supreme Court level. Look at who's in charge, folks. It'll be very good for us, but my gosh, if we have to wait that long, just please tell me that's not going to happen. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.